Welcome everybody to tonight's webinar. Topic, estate planning. Leave a legacy and not heartache. And I love that title because that is absolutely true with asset protection, estate planning, well, and asset protection too, but estate planning really sends a message to your heirs and protects your family and makes things transition smoothly. And those of you who have been through any kind of estate problems in the past, probate or otherwise, man, absolutely difficult to deal with. So it's an important topic and one that we really feel strongly about and something that you should put into place with your estate and take action on. So that's kind of our hope for tonight. So a few announcements before we get started. Oh, end of slideshow, look at that. Nope, I'm gonna go back and not do that one. Let's go back here and talk about this. I was at the end there. And obviously this is not our upcoming dates or webinars, but as you know, a lot of you who have not been on our webinars, we feature a lot of series. And these are over the last couple of years, we have hundreds of hours on YouTube showing a lot of the webinars we've done. And these are just a few sample topics. And we have a lot more than that. So if you want to jump in and do that, we strongly suggest you do that. You can go to YouTube, type in Protect Wealth Academy, and you'll see our channel there. Our channel, when you go there, you can see we have options to go ahead and subscribe. And we strongly suggest you do that. When you subscribe, you'll get notices that you'll have access to all of our upcoming webinars. But you do have to hit notifications to receive notifications. So subscribe and hit notifications. That's one thing I always forget, because if you don't hit notifications, you won't be notified of upcoming postings on our site there. Also, those of you who have been to our 3-day Asset Protection Summit, it's our premier event, the best event, the event that Don and I love so much. And we've been doing, Don, has it been 20 years?
Yeah, we started teaching the 3-day summit in '99. So it's been what 23rd year, I think. 23
years, and over 100 of these now that we've done. And we have some of the best people you're ever going to meet and have the privilege of learning from. It is our passion. It's something we love. Clint Coons is an asset protection attorney, incredible. Scott Estel, former senior trial attorney from the IRS. He's a heavy hitter on taxes. You'll love it. Dr. Danko, co-author of The Millionaire Next Door. Love that book. One of my favorite books of all time. We talk about taxes, self-directed IRAs with Jill. Mike Koval and Stacey Acevedo on stock options and trading. Have some real estate mixed in sometimes. And of course, it wouldn't be the same without Don. He almost tried to not join one time, and it didn't go as well. So we're glad. That's awesome.
Oh, you did just fine, Ken.
Well, you came on the end, so we made it. We have a lot of upcoming events, guys. A 3-day Asset Protection Summit. It really is our premier event. So August 1st, 2nd, and 3rd, and September 12th through 14th are a live stream. So if you're not really wanting to get on a plane just yet, August and September is your best bet. And I love it because a lot of you are busy and it's hard to make time for 3 days to come and see an event across the country. That's why Zoom has been fantastic. So Zoom allows you to do that from your office, from your cell phone, from your couch. I've seen people put it on their TV. My kids even watch it, believe it or not. So Zoom's great. If you want to come see us in person, we actually will be in Phoenix, October 10th, 11th, and 12th. We so love to see you if you can come in person. It's sometimes better for you in person, but I know that's not always possible. But Phoenix, October 10th, 11th, 12th at the Hilton Airport Hotel. And right now, because of the event cost, it is $99 a person, pretty small nominal cost. The nice thing is that gets you access to physical copies of the student manual and physical consultations with the attorneys and advisors, which sometimes to be face-to-face and actually sit down with an advisor is invaluable. So if you can do that, you can sign up at protectwealth.com.
And Kendall, we landed a special guest on this August event. Do you want to tell them about that?
Oh boy. Kevin O'Leary. So we're not supposed to use the Shark Tank name in a lot of things we do, but Kevin O'Leary, if you've ever watched Shark Tank, Mr. Wonderful, he's kind of a bulldog on TV, but the guy is one of the nicest people. I mean, he's from Canada, of course he's a nice guy. He's just a great guy. And we're lucky enough to have him come to our August event. So if you can make it, he will be on the Zoom live. And so I don't know how much time we'll have for questions. He's always running, but gosh, we're so lucky and so excited. We feel honored to have him on. It's going to be a great thing. So if you want to hear from Mr. Wonderful Kevin O'Leary himself, I learned so much last time we got to meet with him on one of our webinars. I can't tell you, someone at his level running as many businesses as he does, it's a huge opportunity. So yeah, August 1st, 2nd, and 3rd. I can't believe I forgot that. Yeah. We're excited about it. Disclaimer, we're an asset protection company. This is not specific legal, tax, or investment advice. This is something that if you are looking for specific advice, you need to seek out a legal competent professional that can help you with that. So that's our quick disclaimer. Of course, Don's going to give some great information tonight. We're super excited about it. I love it. This is one of my favorite topics because, again, I have 4 small kids at home. I've had family that's gone through a lot of heartache with estate planning, and it's been turmoil for so many of you that we've talked to over the years. If you don't do your estate planning right, there's no other heartache worse than that, especially around, when someone passes. It's a big deal. So make sure you do it right. And there's nobody better than Don Pendleton. He's president of Protect Wealth Academy. He's the guru. He is the best of the best of the best. And I do say that with fondness. Don and I have been working together 20 years. I'm pretty much, Don. He's taught me everything I know. And trust me, I have a long way to go if I ever learn a fraction.
Well, and you've just gone through that with your family.
Yeah.
Where, your mother's and her sisters it's separated family by not having something in writing.
Yeah. My grandma passed, she was one of my best friends, my grandma, of course. And it was tough for us when she passed, and they just had a will. They didn't have a living trust, and was not spelled out. And there was a little bit of hijacking going on, and it's been turmoil for my mom and her sisters, and they're still kind of going through it. So it's heavy on the heart, and you'll cover some of that of how to avoid all that, which is beautiful.
Would they, knowing what they know now, would they have spent $2,000-$3,000 to have a trust?
Gosh, we hear that over and over again. I've heard that from family. Gosh, it's too expensive to do a living trust. It's, a couple $1,000s, and a will's free, or it's $99. Why would I spend the money? Absolutely. Over and over again, without question, they'd spend 10 times that to avoid what they've gone through. And that's pretty common for a lot of these. All right. I'm going to share my screen if you're okay. Yeah, please, Don. We're excited to have you. Thank you so much, Don. I love when Don teaches. It's true. All right. Thank you. You're the masterful teacher. Thanks, Don. Thanks, buddy. All right. Well, we are going to cover a lot of ground tonight. And if I can get my screen working, we're going to try to. Looks good. All right. All right. Our topic tonight is trusts, how to create one, how to maintain it, and trusts are really complicated, and they don't have to be complicated. But there's so much confusion. We get so many questions on the hotline about trusts. And so I kind of put together a little cheat sheet for you on the types of trusts that there are. There are trusts that are either revocable or irrevocable. You can call them irrevocable. I don't care. But some change and some don't change. And I'll explain the difference between those. And then there's trusts that kick into place while you're living. Latin for inter vivos, but it's a living trust. So we create it, we fund it while we're alive, and as opposed to a testamentary trust that's created after your death. So the assets actually go through probate, and then a trust is created by the executive or executor or the probate court. And I'll kind of
go through and spend a little bit of time on that, but those are the main types of trusts. And then we look at estate planning trusts, and you have to understand estate planning trusts are really just a trust, but we take one clause out of the 40-page document or whatever it is. Maybe it's 30 page, maybe it's 10, maybe it's 100. We take one or two paragraphs out and we call it, because there's a spendthrift clause that keeps the beneficiaries from spending too much, or maybe from their creditors getting access, or maybe their ex-spouses, or so we're controlling the spend, and we call the whole thing a spendthrift trust. Well, it's really not. It's a trust that has a spendthrift paragraph, and the rest of that is all marketing. Or we take an AB marital trust. Well, okay, it's a regular trust, but we added a provision for when the first spouse dies, this half of the estate becomes irrevocable and the other isn't. We could call it a special needs trust, and that really is a trust, but it's got a 1 or 2 pages in there to take care of a special needs child, so that we're throttling income to them. We don't dump it all on them when mom and dad die and make them ineligible for Social Security benefits or any other benefits, but we're controlling the spend to the special needs child. And we call it a special needs trust, but it's really a trust that has a couple paragraphs in there. And you see, it's amazing how much people call us all the time and say, well, what about this trust? Well, it's a trust. A trust is a trust is a trust is a trust. And this one has this little special paragraph for people in California, or it's a generation skipping trust, which means some of the assets are going to skip the first generation and go to the grandchildren or the great grandchildren. Or there's what we call a Q-tip or a Q-dot trust. Q-tip is when I've got a second marriage, and I've got kids from this family and maybe family kids in the middle, and I want some assets clearly to go to this set of kids and another to go to this set of kids. And if there's a second or a third marriage, if there's a divorce, I still want my kids taken care of regardless. Well, we can do all that in a Q-tip trust. And it's a regular trust that has a couple provisions for its second marriages. There's a Q-dot trust in case one of the grantors or some of the beneficiaries are not U.S. citizens. And so we have to have special provisions in there. But again, it's marketed as a Q-dot trust, but it's really just a trust. And then we call them asset protection trusts. And they can be either domestic or offshore. Domestic, the main ones that you hear about would be like the Delaware Asset Protection Trust, or the South Dakota, or the Wyoming Statutory Trust. These are irrevocable trusts. The Nevada Dynasty Trust, doesn't that sound ominous? Or the Alaska Legacy Trust. Well, that sounds cool. So I need but all of this is, I can't tell you how much marketing goes into these names. It's an irrevocable trust that was created while they were living, most of them. So let me get to some of your questions in just a minute. Let me finish this section, and then I'll answer some questions. But we got a lot of material, and I really designed it to go through and I think be able to answer your questions. But if not, we'll leave a lot of time at the end. There are some tax reduction trusts, like an irrevocable life insurance trust. What that does is, let's say I've got a large estate over what the state or the federal government will exempt. And I want to put this in a separate trust so that it takes the income or the benefit from that life insurance and takes it out of my taxable estate. Well, I can do that with an irrevocable life insurance trust. There's a charitable remainder trust. There's a charitable lead trust. The difference is the charitable remainder trust, I get all the benefit and the kids get all the benefit and of the trust. I get the tax deductions. I've avoided capital gains on the asset. And then at the end of life, usually tied to the second death, the charity gets what's remaining in the trust, as opposed to a lead trust where the charity gets the money first and we get the scraps on the table. And there's a need for both, but both of them are really, or in fact, all of those are really tax reduction strategies that we'll use. Then there's asset-based trusts, and we hear about a land trust. Well, it's a trust that owns a piece of land. It's really not too much more complicated than that. There's a firearms trust or a personal residence trust that takes the personal residence out of our name, but it's a trust. Remember, a trust is a trust is a trust, and there's a college education trust and equipment trust. There's even a pet trust, an RV trust, a funeral trust. We've had people call us and ask us to create an Iraqi dinar trust because their Iraqi dinar is going to RV at any one time, and or a cryptocurrency trust. So we put in language in there that this is allowed to own cryptocurrency. It's a trust, and as much as I'd like to say it's so unique, this is so different than any other. It's a trust that's marketed as such. And then if that's not enough, then there's all the retirement accounts that really are trusts. See, a 401k is a trust. We don't call it that, but it is. There's beneficiaries. It falls under trust rules. There's Roths and Simples and SEPs and the traditional IRAs and profit sharing plans and pension plans. Those are really all trusts. Now, if you'd like, I could create a quiz for you to make sure you got all of that. But for the most part, most of you are going, I don't care. I just want this simplified. And Don just made it really complex. And so let's focus on what are the basics, and the basics are right there. If we can focus on that and you can understand that, everything else falls into place, because a trust is a trust is a trust is a trust, and it's very simple rules for creating and establishing a trust, and what it owns and what it does, that's all semantics for the most part. So let me describe to you the difference between a revocable and an irrevocable trust, because there's some significant differences, and you probably need to know that. Revocable trust, as the name implies, it can be changed, it can be revoked, it can be amended. Anytime you want to, you can move assets in and out and in and out and in and out all day long. It's revocable, amendable, as opposed to an irrevocable trust, which it cannot. Once I've created the trust document, signed it, notarized, and funded it, meaning I put stuff into it, now it owns assets. At this point, it becomes irrevocable, and I can't change it. It's like I'm pouring wet concrete, and it's not going to change. I get all the tax benefits, I get all the asset protection benefits, but I can't change it. With a revocable trust, there's no tax ID number. It's a disregarded entity. Not that there's no tax consequence, but all the tax consequence fall down to me. So whoever are the grantors of the trust, generally, they get all the tax consequence. If there's profits or loss or capital gains or capital loss or whatever taxable event happens, comes through to me because it's using my Social Security number. There is no tax consequence. There's no tax returns required. On an irrevocable trust, now that's different. It does require a tax ID number, and it requires an annual tax return in most cases. All right. The income on a revocable trust is taxed to the individual grantors. Again, it's a disregarded entity. It's not a flow through. A flow through, like an S corp or a partnership, has to report the taxes, has to file a tax return, and all the tax consequences flow through. A disregarded it doesn't exist as far as the IRS is concerned, but all tax consequences come through right to you. Now, as opposed to income as opposed to an irrevocable trust where the income is taxed under trust rules. And so what we do, if let's say I've got an irrevocable trust and it's making money, we're going to pull that money out almost annually, because I don't want to be taxed at a higher rate than any individual rate. And most trust tax rates are much higher than individual rates. And so we don't leave money in an irrevocable trust. Irrevocable trusts give you almost no asset protection. And there are a few exceptions, and that's why I said almost, but virtually no asset protection because of the fact that you can change, amend it, you can pull the assets in and out, in and out, in and out all you want to. And you have full access to those assets. Therefore, a judgment creditor against you also would have access to those assets, as opposed to an irrevocable trust where I've got a third-party trustee. And if it's run the way that irrevocable trusts are, you have to petition, and then the trustee, independent of you, gets to decide whether you get the money or whether you don't. And as a result of you not having access to those assets at will, it can provide really good asset protection. Where I see people getting in trouble is when they start controlling that third-party trustee. And this trust really becomes kind of a piggy bank. And anytime I want money, they give me money. And therefore, you have access to those assets at any time, and you've got a track record of getting access to them. Therefore, a judgment creditor against you can walk right through your asset protection because there really isn't any. You haven't recognized the validity of this entity, therefore the courts won't either. And so asset protection can be provided in great amount in an asset in a irrevocable trust, but the word is can, and it might, and it depends on how you run it and how much control you exercise over that third-party trustee. So I found this online, and I thought it was a really good summary of the difference between revocable and irrevocable trusts. Revocables, see that the lock is unlocked. I can change it. I can amend it. It's flexible. We like that for estate planning. And the main reason we like revocable trusts for estate planning is because life changes and people die and people get sick and there's marriages that go bad and kids get married and do stupid things, and sometimes they get into drugs, and sometimes they end up in jail, and sometimes life happens. And I want the ability with an estate plan to be able to have this be fluid and flexible. There are a few times when I know for sure what is going to happen. This cabin up in the mountain that our family has owned for generations is going to stay in an irrevocable trust because we want this to be a legacy trust, and we fund it and we keep it up and we maintain it. And this is never going to change. Life insurance. I want this irrevocably to go to my wife and then to my kids, not to grandkids or anybody else. So irrevocable, but the benefit to the irrevocable trust is that it provides good asset protection. The negative is that it's very inflexible, and I have to rely on a third-party trustee outside of my control to get good asset protection. I hope this is sort of making sense. And then assets are still in the grantor's estate as opposed to I'm giving up control. I hope this helps understand the difference between the revocable and irrevocable trust. Now let's talk about the difference between trusts that are created while you're alive and those that are created after you're dead. So there's a living trust, and all trusts are either revocable or irrevocable, and all trusts are either created while you're alive or dead. Once we understand this, it really is going to make it a lot easier. Living trusts are drafted by the grantors while you're alive. The testamentary trust is drafted by the executor or the court after you've passed away. Now that's a big difference. The trust, the living trust is funded while you're alive. The testamentary trust is funded after your death. So the assets in a revocable trust avoid probate. The assets in a testamentary trust go through probate, and then the trust is created. Well, why would I ever do that? I'll show you that in a minute. So we pay for the trust, we pay for the drafting, we pay the attorney or whatever for the revocable living trust while I'm alive, but the testamentary trust, it's paid after I'm dead. Why would I use a testamentary trust? Well, a lot of attorneys like that because they get to walk your estate through probate and then they create the trust and draft it. A lot of people don't want to do a trust. And so while they're alive and their procrastination, they procrastinate, and they go, well, I'll take care of it. And so it ends up being a testamentary trust really by default because they didn't take action while they were alive. But there's times, I was on the phone last week with a young couple. They're in their 30s, they've got a couple kids, and they're worried about the life insurance. They've got about $1 million in life insurance, and they made each other, the beneficiaries of this life insurance policy. And then what they did was they said, you know what, we're not going to create a trust. They didn't have any real estate. They didn't have any other major assets other than their jobs, their income. They had a couple cars, but this life insurance. So what we maybe sort of suggested that they consider is have their executor, which in this case was her father. If both of them die and they get this boatload of money for insurance money, then there's instructions to the executor as to what to do, and then the trust would be created and drafted. But right now they don't see any need for it. They don't see, and frankly, I kind of agree with them since they're young and healthy, and the trust can be created and funded by somebody that they know that cares for their kids, that'll take care of the kids. But that could be created after their death if they ever die. But right now they appear to be young and healthy. And so there is a need for testamentary trust, but for the most part, when we're doing estate planning, at least our group and the most of the attorneys that we work with, we're dealing with revocable trusts that are created and funded while you're alive. Not that there's not a need for the testamentary trust or the irrevocable trust, but when we're talking estate planning, most of the time it's a revocable living trust is what we're helping our students understand and create. I hope that makes sense. There are 3 parties to all trusts, and I think most of our students know this, but let me walk through this really fast. There's what's called the trustor, the grantor, or the settler. There are some unique, very, very minute differences between the 3, but it's really the person who creates a trust, who drafts the trust, and if needed, amends the trust. The trustee controls the trust. He controls the trust. He manages the trust assets. He distributes, upon the death of the grantors, he distributes the trust assets. And then there's another one that we all want to be part of, and that is a beneficiary. Somebody's got to receive the benefit from the trust. Now, with a revocable living trust, you can be all 3. You can be the grantor or the trustor. You funded the trust. And while I'm alive, I am the trustee. Now, there might be successor trustees after. And while I'm alive, I'm really creating this trust for my benefit. But upon my death, there's contingent beneficiaries. Those would be my kids or grandkids or whoever. And those are, and even I even see some of the best attorneys kind of mess up the language on this, but trustees have successor trustees. And this came up in our office today. Generally, most trusts are created with 2 or 3 multiple successor trustees. So for our trust, my wife and I are co-trustees. Upon my death, she'll be the remaining trustee. Upon her death, then 2 of our 5 kids will become co-trustees. They're the successor trustees, and there's several people listed in succession. My brother and a few other people, in case one of them don't want to fulfill their role, or they're not capable at the time. And then our bank is listed as the final successor. If nobody else can or wants to do it, it'll be the most expensive option, but it'll be fair and they'll do a good job. They'll take care of the taxes, and I know that it'll get done, as opposed to leaving it to a family member that I don't really know well and don't trust. So beneficiaries, again, there's contingent beneficiaries if I'm not there. So I hope that makes sense. So I like to think of this in terms of baseball caps. There are times when you're going to wear your baseball cap. And years ago, I created these little caps to teach the principle, and I haven't used them they've collected dust most of the time. When you're creating and funding the trust, you're wearing your little trustor cap. If this is an irrevocable trust, once you've created this trust and funded it, you throw this thing away because you don't need it anymore. On a revocable trust, you might need it. You might have to come back and amend it, and you might have to do things. So that's the trustor's job, is to create and fund the trust. Then there's a trustee. Yep. And the trustee's job is just follow the babysitting instructions. Don't get cute. Don't try to create things that aren't in the trust. You don't have a lot of leeway. Your job, you have a fiduciary duty to the trust to follow the babysitting rules. That's the trustee, to manage the trust assets. And then the beneficiary doesn't do anything. Oh, gosh, we don't want them to do anything other than take the benefit of the trust, but not an active role. We just want you to play the part. A revocable living trust, we consider to be, I call it the collection distribution entity. And what it does is it holds, disposes of personal assets. I'll show you how this works, and your interests in other entities. So I'll show you that. So I have a stock in a corporation. I've got an interest in a limited partnership or an interest in an LLC. Everything eventually comes down into our trust. It avoids probate on the assets that we put into it. If we funded the assets properly, then it will avoid it'll avoid probate. If we didn't put an asset into the trust, that asset is likely to go through probate. And we've kind of shot ourselves in the foot by having a trust if we never funded it properly. It can avoid or reduce estate taxes on large estates when we're over the exemption amount, which federally right now is about $12 million. Some states, your state taxes kick in at about $1 million. Some states have inheritance taxes, some of them just estate taxes in addition to the federal. But a trust can help you avoid or reduce your estate taxes. What is probate? The probate is really the legal distribution of your assets upon your death to your heirs as administered by the probate court. Now, I know that's a technical term. So it's basically, if there's not clear title to an asset after you die, it's kind of, in Catholic terms, it's kind of in limbo. Who owns it? Well, I don't know. So somebody has to decide who owns this asset. So let's say I've got a home. It was clearly in my name. I'm dead. Who owns the house? Well, somebody has to decide that. And if I didn't provide succession, I didn't have a transfer on death deed, or I didn't have a trust, or I didn't have some type of, here's who owns this when I die, then that will go through probate. Here's the problems with probate that I see is the time. Some states like Texas, 9 to 12 months generally, fairly simple probate. New Jersey, fairly simple probate. A lot of tax issues, but simple probate. California, I've helped both of my parents-in-law after they pass away. And oh my gosh, the time, the expense was incredible to figure out, and all the paperwork to go through the probate process. If you figure on average, most estates nationwide, I think the average is about 1.5 years for an estate to go through probate. But you have to understand those numbers are a little bit skewed because most people die broke. And if I had a large estate or a sizable estate, or I've got assets at all above being broke, you understand that it's going to take a little bit more time. The average expense is usually 4 to 8% of the assets that are going to go through probate. Add it, pile up everything you've got, including all the equity you have, the life insurance, anything that's going to go through probate. Add all that up, take out the debts, because the process of probate is going to pay off all those debts, your credit cards, your mortgages, everything, whatever's left. Figure about 4 to 8% right off the top to figure out who's going to get what's left. And for some of you, that's a sizable chunk of money, as opposed to having somebody draft a revocable living trust and fund it and spend a couple $1,000s. Like Kendall said, the people that I go through that have gone through probate now would have paid for a trust 10, 15, 30 times over had they known, but it can be expensive. Most jurisdictions, everything that goes through probate becomes a matter of public record. And once a probate has begun, it cannot be stopped. It will go through until the end. And if you own property in 3 different states, you get to go through the lovely probate process 3 different times, because wherever there's real estate, there's going to be a probate if we didn't take proper steps. Those are our problems that I see. So I see really 2 ways to avoid probate. Number one is don't die. I don't know anybody that's ever gone through probate that's still alive. And that sounds funny, but the real way to avoid probate is to use entities that don't die. If you pass away, the corporation you own didn't die. It still lives. It still lives. Who gets the stock of your corporation? There might be a question in that. But your limited partnership, your LLC, didn't die. Those are entities that can go on for years. Family foundations go on for centuries. Charitable giving, charitable remainder trusts go on for 25 years after your death. See, all of those things don't die. Living trusts don't die. So we use entities that don't die, and that's really the way to avoid probate for most. I threw in this little slide just for fun. If you like your attorney more than your kids, have a will. If you like your kids more than your attorney, have a trust. And then I threw this one in as well. Probate is an excellent way to get to know your attorney better. Or you could use a trust. All right, hope that makes sense. And some of you go, oh, wait, but I have a will. Okay, good. You have to understand what a will is. A will is directions to the probate court as to what to do with your estate. Therefore, a will guarantees probate. Your estate becomes a matter of public record, again, in most jurisdictions. It's a flag to the unscrupulous. You think you're getting a lot of requests for donations and charitable giving right now. Wait till you receive something through probate in a county that makes it a matter of public record, and people follow these things. Are you kidding me? You think that you're getting requests now? Just wait. It's easy to contest a will. In fact, statistics show about 25% of all wills will be contested. That's not why they call it a will, but the statistic is still true. Have you ever heard of trust being contested? And they can be, and they occasionally are, but not very often. And so if you're trying to avoid disputes, spell it all out, and we do that in trusts. We don't do that in wills. if we have a trust and we fully fund it and we put all the assets into it properly, do we still need a will? Yes, for most, there are several reasons, but two in particular. One is, remember, the trust can only control that which it owns. And I can't retitle the children in the name of the trust. So the will provides guardianship for the children. It provides, here's what I want done with the pets. There's things that I can't, that the trust can't do. And then there's what's called a pour over provision, POUR. It looks over, scans over, pours over your entire estate and goes, oh, you forgot the china cabinet to put that in. You forgot the tools in the garage. You just bought this piece of investment property. Okay, that's going to go through probate, but it'll be an easier probate because the pour over will sends everything over to the trustee where the trustee can control it. You see what we're doing? As again, the trust can only control that which it owns, and there's certain things that the trust can't own. Therefore, we still need the will working in conjunction with the trust. Oh, the games people play. Have you ever noticed all the attorneys and the law firms and the people out there that are saying, oh, look, we'll create a will for you. In fact, it's free, just no charge, free. We'll create a will for you. Why are they doing that? Because they know if their law firm has stamped on the bottom of your will their name and address on the bottom of every page, and they do, they know that about 72% on average of the people after mom and dad died, the kids are, well, mom trusted them, so we're going to go back to this same law firm. And that law firm gets to walk you through probate. Ooh. Well, so the last will and testament becomes a lost leader for the law firms. Oh, is that cool? In fact, we were Kendall was at a 4th of July party, a big parade, and he noticed that there were attorneys passing out flyers there that saying Free Will Wednesdays. Like, come into our law firm on Wednesdays. We'll create the will for you for free. Why do they do that? Again, they're looking for other opportunities and they want to walk your estate through probate someday. You have to kind of understand the game here. Revocable trust, I want to just twist it just a little bit and compare it to almost everybody in the US has a big popcorn Tupperware bowl, don't you? I mean, you never put it in the cabinet empty. You always you'd take all the little Tupperware bowls, stuff it inside, then put it in the cabinet or the pantry or wherever you keep it. I want you to picture your revocable trust as being this big bushel basket or this big Tupperware bowl. And the process then of connecting the assets to this revocable trust, we connect or we attach, that process is called funding the trust. It's not really a technical term. I call it putting stuff in, but it's called funding the trust. And you hear of that often, but a lot of our students don't really understand that. And remember, a trust can only control that which it owns. If you didn't put an asset into the trust. So how, and we'll talk about this in a second, but let's say you want to put your home in the trust to avoid probate, or a bank account. And so I would go down to the county recorder and file a deed and transfer that out of my name into the name of the trust. If I don't do that, the trust can't control it. Therefore, that asset will go through probate. That bank account, that brokerage account, that piece of property, this is called funding the trust. And at the 3-day summit, we're going to spend a lot of time, at least 2 hours, talking about how to fund the trust and how to do that. So, but let me go over some stuff really quickly. I think most everybody knows that their home probably ought to be in the revocable trust. Most of you know that your bank accounts and brokerage accounts probably ought to be assigned to the trust. So again, so that they avoid probate. If you have rental properties, they might be in an LLC first, but but then that LLC is going to come down into the trust. If you got vehicles, we could assign those to the trust. Then there's two assets that sometimes get left out. And I drew a kind of a dotted red line on this. An IRA is a trust, remember? And there is a beneficiary. So for me, my wife, I'm the beneficiary of my IRA. I set it up for my benefit when I retire, but my wife is listed as the contingent beneficiary. And then I listed the trust as the second contingent. So I don't have to tie that in. I could drop that right onto the kids, but I kind of like to exercise a little control and have some strings and have spendthrift clauses and so I listed the trust as the second contingent. Life insurance is a little bit different. I didn't list myself as the primary beneficiary because presumably I'm not here when I get life insurance proceeds. So I listed my wife as the beneficiary, but I listed the Revocable Living Trust as the contingent beneficiary. Now you don't have to. It will avoid probate, both the IRA and life insurance. If there's a beneficiary still alive, it avoids probate. But sometimes I like the exclusions and the drafting documents that are included in the trust, and I want those assets to come down to the trust. Sometimes I don't. So dotted red line, I hope that makes sense. Most people sort of understand that. Where our students tend to get confused is, what if I own a corporation? Oh, upon my death, I want all my rights and interests. In fact, I could do that right now. Instead of issuing the stock certificates in my name, I could list them in the name of the trust. Instead of me being the member of the LLCs, I could list the trust as the member. And so whatever business interests we have, I own 40% of this, I own 60% of this, I own 100% of this. Upon my death, I want all of these transferred down to the trust so that those interests do not go through probate. And so we've got this big bushel basket. In this case, it's not red, it's yellow, but you get the idea. And I'm conveying my assets to the trust and all interests in other businesses to the trust. And sometimes when we're talking about this, it's a big job to fund a trust. It's not just about creating the trust. It really is about funding it and funding it properly. All right, there's two ways to fund a trust, and I'm going to go through a few more slides and then we'll leave a lot more time for Q&A. Two ways to fund a trust. One is we could retitle the asset in the name of the trust. So again, the bank account is not in my name, it's in the name of the trust. Or I could use a Schedule A. And what that is here's the trust document. And in this case, it's 50 pages long, and then I slap on an appendix. Or it could be Exhibit A or Appendix A or Schedule A, generally known as a Schedule A. It's not like a tax 1040 Schedule A. It's just it's an appendix. We slap that on and say, here are the assets of the trust. And so we could go through and we could retitle the home. And in most cases, the best way is whenever possible, we do both. If there's a title to an asset, we would retitle it and list it on the Schedule A. Now I go to the bank account, I retitle that asset, I go down to the bank, fill out their form, show them a copy of the trust or a certificate of trust. I'll get to that. And therefore, I've changed the title on the bank account or the brokerage account, and I've listed it on the Schedule A. There are some assets that don't have a title. The grand piano doesn't have a title. So I simply list this on the Schedule A. Here's make, model, serial number of our Yamaha grand piano. Or I list my wife's wedding room, not just list it, but I take a picture of it and say, this wedding ring right there. And so the Schedule A becomes a very important document to the trust. All right, so at the summit we're going to spend, again, we're going to spend a lot of time on this. Let me give you the language that I would use. let's say I'm a single person, I want to change my home and I want to retitle that. And so what I would do is the language I would use is something like similar to this: Fred Q. Wilson, trustee of the Fred Q. Wilson Revocable Living Trust. I don't care if it says revocable. I don't care if it says living. You could just say the Fred Q. Wilson Trust. But the language that we use, and it would show right on the title to the home or the title to the bank account, it would say Fred Q. Wilson, trustee of the Fred Q. Wilson Trust. It would say that. Now, it won't say that on my checks, but it will say that on the bank statement. And it's owned actually now, therefore, by the trust. For a single person, we do that just a little bit different because you've got three options. I could list it in the name of the family trust. And in that case, I would go Fred Q. Wilson and Emily A. Wilson, trustees of the Wilson Trust, Wilson Family Trust. We go Wilson Family Revocable Living Trust, or whatever the name of your trust is. That puts it as an asset that's jointly owned by the trust. But I could also, let's say this is coming from a second marriage, I've got kids, I want them taken care of, and I want my wife's kids taken care of. So I could put this, I would just retitle it. I'm putting it into my trust, not my wife's trust. Therefore, I would go Fred Q. Wilson and Emily A. Wilson, trustees of not the Wilson Family Trust, but the Fred Q. Wilson Trust. And so that's saying, and even though there's not three different trusts, there sort of are. With Emily, I would say Fred Q. Wilson and Emily A. Wilson, trustees of the Emily Wilson Trust. So yeah, I'm taking this bank account or this piece of property and saying this is in our marital trust, but only on this side of the trust. And therefore, stipulation to that trust is that these would go to my children. You see what we're doing? That titling becomes very important. Oh, the games people play. Remember, we talked about Free Will Wednesdays and why so many law firms are so happy to set up a last will and testament for you. Yeah, you sort of have to understand the game again that the attorneys will play. How a law firm and estate planning law firm is sold is based on the assets and the income that it generates. But a lot of the value of a law firm will depend on the files that they have. Here are all the files of this law firm. On the right, here are all of the last will and testaments that we've created for people. They know, again, about 72% of the people are going to come back. We know that this file right here, that's about $1 million estate. This one's 1.2 million. We know that we get to walk them through probate, probably let's figure 8% off the estate. And we set the value for this law firm based on their accounts receivable. Ooh. And then we go to the other side of the aisle, and here are all the unfunded revocable living trusts that the law firm has set up. And what they don't tell you that is most attorneys never fund the trusts they set. I estimated about 90% of the time when an attorney has set up a trust for you, they never funded it. And they say, well, because it saves you money, and there's instructions back on page 72. It shows you exactly how to do it yourself, but most people never do it. And so most trusts, as you paid the attorney to do it, but you're still going to go, the assets are still going to go through probate. The games that people play. Yeah, once you understand that, and you understand the value of not only creating the trust, but funding it and keeping it up to date. It's important that maybe the trust doesn't need to be revised every year, but the Schedule A probably ought to be looked at and maintained. This is a funny little cartoon we've had for years. Honey, tell me one more time. His husband is dangling by a little branch. Is mine the A trust or the B trust? Anyway, you have to be a little goofy maybe to understand that. Okay, we just have a couple more slides, and then when we ask an attorney to create a trust, let's say you're working with the Anderson Law Group or anybody that you're working with, the trust is kind of a generic term. What it generally means is there is a trust document. Here's all my wishes upon my death. Here's the babysitting instructions. Here's what I want. And it could be a Q-tip, it could be a Q-dot trust, it could be spendthrift, it could be a special needs, but it's a revocable living trust. Here's the documents that we do. And then there'll generally be a Schedule A. Here's the list of the trust assets. And then there might be what's called a personal property memorandum, because I want the rose-colored china to go to Susie. And I want the binoculars that were great-great-grandfathers, and he crossed the plains all the way along the Oregon Trail. And these I want to go to Freddie. And okay, so this is specific items, irregardless of the rest of the value of the trust. Maybe there's not a lot of money value to them, but there's still value to them. Here's what I want, the procedures of death. I want to be cremated. I don't want to be cremated. Here's what I want sung at my funeral. Here's the flowers. I don't know, whatever the procedures of death. You can spell that out. That's also often part of the trust. And then there's what's called a certificate of trust. What that is really kind of a summary of the trust. And generally, you don't want to go down to the bank and give them, here's my whole trust document. Here's all 96 pages of the trust with all the appendages, and it's none of the banker's business. And so usually on 1 or 2 pages, we can do a summary. It's the Cliff Note version. Here's the name of the trust. Here's when it was instituted. Here were the trustors. Here are the trustees and the powers that they have to set up this bank account. And so that's called a certificate of trust. And I generally discourage our students from giving the bank, or the county recorder the entire copy of your trust, because I figure it's a private document and it's none of their darn business. So I like these little certificates of trust. Then there's funding documents. There's quit claim deeds. Sometimes you use a warranty deed. I'll explain that in a minute. In general, if you're just transferring a piece of property into a trust that you own, I would use a quit claim deed. If I'm trying to use a land trust or I want to hide the identity, then I would use a warranty deed. So it doesn't look like it's going just to me. There's letters to banks. There's letters to brokers. There's your last will and testament. That includes, again, guardianship provision for your minor children, the care of pets, your pour over provision, as we explained. The procedures of death could be over here in the last will and testament. This is where I like to put passwords and bank account numbers, and so that your trustor or your trustee or your executor, whoever's left, can figure out how to manage your affairs. Financial powers of attorney. They could be general in nature. They could be springs into action upon your incapacitation. The durable power of attorney means it ends at death, but it's durable from the time of incapacitation all the way till death. Powers of attorney always end at death, and then the trustees or the executors take over and run from there. There's advanced care, healthcare directives. In some states, they split it, and it's a living will, and it's a medical power of attorney. These things are all combined. Let's say you hire Anderson, and I don't know, whatever they charge you, $2,000 or $3,000. They create a trust for you. It really includes everything that we're saying here. And if you're hiring an attorney, and I can create this trust for $700 for you, we're probably only looking at the trust document without the ancillary documents. And for large estates, it's going to cost you a little bit more. I'm not giving you a round figure. I'm teaching a principle. So there are some special drafting requirements. Anytime there are times. Let me be blunt and honest. There were times when we were young and married and they owned a piece of property, a simple trust is all we needed. As we got a little older and we had 5 kids, and one of them gets into a bad marriage, and one of them moves to a community property state, and one of them has health conditions, and one of them has never graduated from high school, and 3 of them have gone through college, and they've gone different directions, and they've done different things, and some of them are interested in real estate, and some of them are business people, and some of them have jobs of their own and don't really care about what I do. And so as life has got complicated, we've had to amend our trust on several occasions. And there's times when I want you to do it yourself because it's just simple. And a simple little trust that takes a piece of real estate or a bank account and avoids probate is a simple thing. But when our life gets complicated, there's times when I don't want you to do it. And even though we've sold a home study asset protection kit that includes trusts, there's times I really don't want you to use those. If you have special disabled or special needs kids, I need that to be custom drafted. If we've got unequal distributions for the children, this child I've already helped a lot, and we're not going to make it equal distributions. Second marriages and blended families require special drafting, special limitations or conditions on distributions. My kids, if they don't read the Bible 3 times, they don't get anything. And I'm not saying that, but there's times when we want them to graduate. We want them to get a degree. We want them to perform different things. We want them not be criminals and drug use. And so sometimes we'll put limitations or conditions on those would be drafted into the documents. Sometimes there's customized incentives. We had 3 of our children that wanted to serve service missions and go abroad and do good things. Well, we encourage that because we believe in that. Sometimes you might want to disinherit a certain beneficiary, or maybe we've got either the grantor or some of the beneficiaries aren't U.S. citizens. And so now we need QDOT provisions, or I want spendthrift provisions because I know that one child, they're just going to blow through the money, or I'm worried about their marriage, or they've got debts to the IRS and I don't want the IRS to get access to their inheritance. And so we can do those through special provisions. Generation skipping ideas. I don't want everything to go to my 5 kids. I want some of it to go to the grandkids. Large estates over 12 million definitely need some special drafting. And there's so many other things, and I don't want to go into everything. But here's what we're offering tonight, and really quite always. If you'd like a free consultation with an estate planning professional, sign up for it. Just go to protectwealth.com/trust. There's a very simple thing, and we'll get you in touch with somebody from Anderson Law Group, review where you're at. If you've already got a trust, let's review your funding documents. Let's see where you're at. Maybe we don't have a trust. Maybe I don't know if I need a trust. Let's do a consultation, and we're providing this for free. And then we'll also provide a lot more information when we come to the summit. Again, that one is the next one coming up in 2.5 weeks is August 1st, 2nd, 3rd. Kevin O'Leary plans on attending. There'll be a live stream in September and a live event in Phoenix, Arizona, after the 120-degree heat is over. So that was really all I had. And so let's turn and let's answer some questions. John is asking, any recommendations for someone who's 80 years old, has no children, and a wife who's financially comfortable? What do we do with his assets? Well, John, the very first thing I would do is look at what real estate they have. And we still want, even though there's no children, we still want that. We want the wife to be comfortable. If the 80-year-old passes away, we still want first priority to take care of the wife and have her live in the comfort of which she's accustomed. And then as opposed to it going to the state, and maybe that is the plan, but as opposed to that, there's probably charities, there's probably nieces and nephews that you could contribute to. All of those types of things could be spelled out in a trust. If there's no real estate and no real assets, then I don't see any need for the trust. But it sounds like they're financially comfortable, which means that they have assets. And if they have real estate, uh, almost always that's going to require a trust to avoid probate. Lisa, if we need a living trust, can we contact your group and create these things for us? And the answer is yes. And again, I just offered that for you. Go to protectwealth.com/trust and do a consultation. I know that you wrote this an hour ago, so but I'm just getting around to doing it now anyway. That one. Mary, I currently have a living will and a revocable trust. I have all the asset beneficiaries designation as my trust. I've recently been told that I should not, keep skipping, set the beneficiary for pre-tax funds designated as the trust. It could cause tax issues for all assets in the trust. So what I believe you're saying is, Mary, we have a Roth IRA, and I don't want to move this down into the revocable living trust. And that may very well be. And could you have a special needs trust? When we are going to send an IRA money or 401k money down to the revocable living trust, it needs to have special drafting inside of the revocable trust to be able to do that. And when you receive, let's say there's, I don't know, $500,000 in my IRA, and that comes into the trust, it's going to be treated as a separate trust, and the kids still need to spend down begin spending within 5 years, and that will be a trust within a trust. But it doesn't take away the tax consequences of either the traditional or the Roth IRA. They still remain in that, and all the rules for inherited IRAs would continue, even though it's kind of controlled in the distributions. What would happen is maybe one of the kids would receive the inherited IRAs, and the others would receive the real estate, and somebody else would receive the insurance, but it would be controlled by the trust document itself. What about a special needs trust? I think that I've covered that. I love special needs trust when I've got special needs children. Anytime I've got disabled kids, I don't want to dump a lot of money on them. We want to throttle that up to the maximum to provide for their care, provide for their comfort, but not dump a lot of money on them and make them ineligible for the benefits that they get. Have you heard of a land trust? Oh my gosh, yes. And in fact, I've got a whole presentation on land trusts tomorrow, but I don't really have time to probably cover that tonight. But yes, we deal in land trusts all the time and love them for the right reasons. I thought an ILET is not tax deductible for the money that goes in. That is correct. Is it tax-free for the benefit? Generally, the money coming out of an ILET, the insurance, is tax-free. The taxes, but I'm paying for the premiums, the insurance premiums after taxes. I hope that answered that. Typo, while you're alive, while you're alive. Yeah, well, thank you. I'll go back and change that. I appreciate that, Benny. William, are timeshares owned in different states considered real estate for probate purposes? No, it's generally not. It's a share, and it's generally not considered. You really don't own the real estate. You own a timeshare, and for the most part, it's an asset that's really well protected. Nobody wants it in a lawsuit. It's like an annuity. Nobody wants to take over your annuity in a lawsuit and get 40 cents on the dollar if they go to JG Wentworth. And I'm not sorry. It's just nobody wants your timeshare, and so and be really careful, because sometimes those are generational, and whoever inherits your estate also gets all the maintenance and all the fees associated with your timeshare, whether you like that or not. Be careful of timeshares. I generally don't put those into a revocable trust. I guess you could, but I haven't seen a need for it. And no, there's not different deeds to the properties in different states. Benny, I've heard that automobiles shouldn't be in a trust because of liability issues. Well, there's some mixed feelings on that, Benny, and I understand the value of both. Jay Minton used to tell me that he always wanted the bulk of a person's estate to avoid probate 100% of the time, but there's always one or two assets, and he included cars in that. If you only have one or two cars that go through probate, good. Then that's a good idea. Remember, the probate process is kind of like Old England. Hear ye, John has died. If anybody has a claim against the estate, but after that 3 months or 6 months or a year or whatever, gavel comes down and says all claims against this estate are all ended. There is a need for probate, just if nothing else, to stop all future claims against the estate. And if one or two vehicles goes through that, then that's okay. I'm not worried about liability. So Benny, not at all. Everything inside of the trust has liability. Your home, the trust is not an asset protection tool. It's a probate tool, and putting an asset in a vehicle into your trust isn't going to either create or reduce your liability, because it's a disregarded entity. It is a non-existent entity for the courts and for the tax, for the IRS, until you die. And then it becomes, so I don't see that. I do see automobiles sometimes shouldn't be put in a corporation. You're driving around in your car, and okay, this was really personal. I went to the grocery store. While I'm going to the grocery store in my company vehicle, I run into somebody. I create an accident. Now the corporation is also involved because it was an asset of the corporation. But to put a trust or a vehicle inside of a trust, I don't see that it would make a bit of difference for liability. Okay, Bob, does your vehicles in the trust present a risk? I think we just answered that. Benny, I thought IRA beneficiaries should be real persons, so you could extend over. Generally, as I mentioned, my IRA, I'm the beneficiary. My wife is the contingent, but I can list a living trust as a contingent beneficiary. And in fact, I've done it on mine and several other people's estates. So yes, it's possible. Keith, what if your real estate has mortgages and your vehicles or boats have loans on them? Can you attach them to the trust? And Keith, really, really good question. And I'm sorry I didn't cover that. 1983 or 84, there was a federal law, and the little background to this is that interest rates were 14, 16, 18% on a home mortgage. And what was happening is it had gone so sky high that the mortgage companies, the banks, were going sniffing around at the county recorder's office, finding anybody who had transferred or conveyed their home into a revocable living trust and calling the loan due. Say, oh, yeah, you had a great 4% interest rate, but we're going to call the loan due, and the best you can qualify is an 18%. Either come up with all the money or we're going to refinance the loan. So 83, 84, there was what's called a Garnet St Germain Act that made it illegal for companies for banks, lending institutions to call the loan due if you had transferred your home into a revocable grantor trust. So it's revocable, it's created while you're living, it's a grantor trust, and the banks can't call the loan due. That's one of the reasons, going back to a land trust, why we use this. So can the bank, generally, when you transfer your home out of your name, there's a due on sale little paragraph that says we're going to call the loan due if you transfer this out of your name. But the exception would be if it's going into my revocable grantor trust. They can't call the loan due on that. So hope that makes sense. Can the IRS pierce any trust? Yes, there's no, Keith, there's no asset protection for a revocable living trust. Can the IRS pierce an irrevocable trust? And that would be, they would look at the trust document. They would look at what you're doing, how much control. But yes, even irrevocable trusts can provide a good asset protection from even the IRS or any other creditor. Can the IRS pierce trust? Yep, we got that one. Is there only one trust? So there's only one trust? Benny, I don't know if I answered that or not. Lisa, presentation is amazing. Just noticed a spelling error. HIPAA rather than, okay, thank you. Kendall, will you note that and great. Crystal, what would you say are the most common and beneficial trust? I don't understand. Kendall, help me out with that. What's Crystal saying?
Well, it just goes into successor trustees seem to be trustworthy individuals on a scale of your own discretion.
Oh.
Assuming trust only done through attorneys. Can instructions be given to a revocable living trust get in a will?
We could teach a whole seminar on how to select a really good trustee. And people, oh my gosh, I've seen so many horror stories where they thought the brother was going to take care of it. Kendall, in your case, it was the sister who really is kind of robbing the whole rest of the estate. But with my wife's family, they picked a trustee. There were 5 kids, and all of them got along really well, except for the adopted son. And he really wanted to be the trustee. And so they went, okay, well, that's fine. Well, he had a chip on his shoulder, and he sucked that estate dry. It was a multi-billion-dollar estate. It took him 19 years to finally probate. And the only reason they were able to do it in California in 19 years is because he died and the other trustee came in and took over. But he sucked that dry. And you really need somebody that you trust, that understands you, that understands your wishes, has the best interest of you and your kids in mind. And almost always that's going to be separate than who raises the kids. The person who controls the money, you don't want to be the person who controls the raising of the kids. Almost always there's going to be different. Do they need to be trustworthy on a scale? Yeah. The word trustee kind of suggests that they be trustworthy. I love you to touch on a real. Thank you. I'll think about that, and I know I've got lots of horror stories to tell you. If I have one child and there is no ongoing contest to the will, do we still need a trust? Yes. You don't need all the provisions saying what if this and what if this and what if this, but all of those assets are going to they're going to go through probate. The purpose of the trust is to collect everything and distribute it without argument, which, okay, with one child you're not going to have, and avoid probate. So you don't want to create a mess for him where it takes him 2 or 3 or 4 years to get the assets, and only 90% of them are left. After attorney fees, there's only 80%. After court costs, there's only 70% of the assets left. If your only child is the trustee of the trust, and he can clearly convey the assets, and tomorrow he owns everything, controls it all. It's really about succession and avoiding probate. It's not always about avoiding disputes, although sometimes it just is. So the purpose of the revocable trust is to keep the assets from going through probate and not protecting them. Correct. We use limited partnerships, LLCs, sometimes corporations, to separate assets from each other, businesses from each other. We put rental properties, for instance, in LLCs, but we tie that down to the trust. Your asset protection layer is really your LLCs and limited partnerships. Sometimes your IRAs, sometimes your 401ks. They provide, those are your asset protection entities. And then the trust is really there to avoid probate. You mentioned the revocable trust serves as a poor asset protection against creditors. That's true because it's revocable. Does the same thing apply for liability such as lawsuits in a highly litigious field? Absolutely, Mike. That's exactly what we're saying. Is the revocable living trust, because it's revocable, amendable, you've got access to all those assets. It really doesn't provide a lot of asset protection. It's really, if I put things in, let's say, husband and wife's trust, and the home is clearly in her trust for 20 years, and I get sued, is there some degree of asset protection where a judge might say, you know what, this was done for estate planning purposes, therefore it's exempt from this lawsuit? Yes, but even though I had access to it, the fact that I didn't, that has some weight, but that's why I say almost no asset protection. But really, it has almost none. The cost of a trust, is there a monthly or yearly cost? No, there's not. Also, is there ever a cost if I amend the trust? Well, if you amend it yourself and you add on a document and say this, you know, remember, whatever you can put into writing, you can put into that trust. And if I want to disinherit a child, I can do that. And if I want special stipulations, I can do that. And if I sell an asset, I could cross out and put sold on this date. So there are certain things that if you feel comfortable doing and you know how to do it correctly, well, that's fine. But the trust, again, doesn't need to be amended all that often. It's the Schedule A, the list of trust assets that might have to be updated. I recommend yearly. Doug, good to see you on. I have a small family and don't have a backup beneficiary named in the event something happens to my beneficiary. You mentioned you have a bank named as your backup beneficiary. Can you go briefly how this works? So what I did was I listed, me and my wife are contingent beneficiaries. I listed my brother as the next, or I'm sorry, successor trustees. So I listed my brother as the next successor, and then my two oldest kids as the next successor. And then after that, I listed the bank. Meaning I don't want this to have to be a committee with all 5 kids getting together and figuring out who's going to do things and require 5 signatures. And so that was the succession, but I see large estates where they list 2 or 3 people and then they list a bank. Bank will always be fair. They'll be expensive, but the bank's trust department will get the job done and they will file all the proper IRS documents. They'll once the trust becomes irrevocable, they'll file the tax return on time. They'll do it right. And you know how justice is blind, that they don't care about the personalities of the kids and the arguments it's going to create. They're going to follow the trust document. So it could be an attorney, it could be the bank's trust department, it could be somebody. There's a pro and con for all of that. So hope that makes sense, Doug. Again, good to see you. Marilyn, do banks with your trust accounts have the right to tell you how many medical letters the successor trustee needs to prove incapacitation? I think that would be controlled by the state. It wouldn't be the bank itself. I don't know. That's a good question. Could the bank have specific policies? But I believe that would be controlled by the state, not the bank itself. What are the definitions of incapacitation? Well, that's a really good question. My wife thinks I'm probably incapable right now of a lot of things. But it means that you would have to be proven incapable, and several people would probably have to attest that you're not capable of managing your own affairs, or medically, you know what, I'm in a coma and I don't know. Generally, this is a medical decision that I'm not equipped to do. Okay, Kendall, how are we doing on questions and how are we doing on time? I'm not even looking.
You're getting close. You got 4 minutes. 4 minutes left technically, and about 20 questions or so.
Okay, I better go faster. My wife and I have our primary cars titled. Maybe Kendall, if you can go through and sort some of these out and combine a couple of them, you can. My wife and I have primary cars titled with each other as a survivor. Okay, that's good. Then that would avoid probate as long as one of you are there. My advisor set this up so that we've got a transfer on death on our IRA accounts. Okay, that's good. And another is called a paid on death, POD, on bank accounts. That's good. So those things avoid probate as long as your wife is still there. If both of you die in a car accident, then that also obviously defeats that. Both of our names are on the home deed. Does this eliminate probate as long as both of you are alive and there's a successor to one of you? But when the second to die dies, then all of those assets would go through probate. And so, yes, you've avoided it. I like these PODs and TODs. I'll talk about that when we get to the summit. That avoids the first set of probate, but it doesn't avoid the second when the second that spouse dies. Laura, my husband is a university professor. We have a revocable trust done through an attorney that was paid for through the university. I don't know the details. Should I suggest to my husband that we revisit it? I would always take an interest in reading that. And it may be long and it might be boring, but it's your trust. This is your legacy. And I would never let somebody, an attorney that doesn't know you, doesn't understand your kids and your personalities and create a trust off the top of his head. I would always, Laura, you get involved. And I know legal documents are legal and they're scary, but oh my gosh, I would absolutely read it and see what you have. Can incapacitation have a specific duration with a beginning and the end rather than just permanent? Absolutely. There's a springing power of attorney. I went into a coma, but then I come back and I'm revived again. And yes, that should be in the documents that what minute I'm revived. Or sometimes it's not springing. My son served a 2-year mission. And what we did was a limited power of attorney while he was gone in another country. I had the power to sign his bank accounts and open his mail and fill out his IRS forms. And I had limited powers, but it ended the day he came back. Always powers of attorney can begin and end either with incapacitation or a certain specific time period. We'll see sometimes I'm going to Europe for 3 months and, during that time, I'm giving you the power just to do this one real estate transaction, or I'm giving you the power to act in my behalf. It could be limited in scope. It could be limited in duration. Powers of attorney are definitely custom drafted. All right. I'm planning to sell 2 commercial buildings, which we've held in retirement funds. Now we're concerned about high capital gains. If they're in retirement funds, there will be no capital gains, Kenneth. If you've got this in a 401k or IRA, they're tax exempt. Should I consider held as not in retirement funds, but as retirement funds? I see. Should I consider irrevocable charitable remainder trust or any other suggestions? A CRT is a really good option to avoid something that's highly appreciated, especially when you have multiple properties. I could pay the taxes on this one. I could do a 1031 exchange on this one. I could do this one as a charitable remainder trust. You take the back tax benefits, and I wouldn't do a charitable remainder trust on everything we do, but it's a great tool for if it's for the right reason. So Kenneth, give me a call on that one and we can walk you through and see if that's appropriate for you. The main question is, what do I want to do with the money once the commercial property is sold? And if it's all I'm looking for is an income stream, a CRT might be a good option. Does a home inside a trust make your beneficiaries lose the advantage of step up? If it's a revocable living trust, no, you don't lose the step up basis. When you pass away, the kids inherit it with a step up in basis, the capital gains go away. Marilyn, are doctors generally agreeable with providing incapacitation confirmation letters to a successor trustee? If you have HIPAA provisions and can get access, and say, yes, I have the ability to see the records, then that's been my experience, but I don't spend a lot of time in hospitals, and that's not my expertise. I don't know. What if a successor trustee is unable to obtain the medical letters providing incapacitation? Then you won't have our power to act in that person's behalf, either medically on the medical power of attorney or financial. If you can't prove incapacitation, you don't get that. Your power of attorney never kicks in. If you have equipment in a holding company, does it protect it from probate? Well, it depends on what your holding company is. If it's a let's say it's a corporation, or let's say it's a limited partner, an LLC. This is my holding company. It owns all the equipment. I died. Well, the LLC didn't die. What happens to my 60% interest in that? That might go through probate. If we've made the trust the member, or we had a designation of successor and interest clause, which says, I'm the member all the days of my life. The second I die, I want all my rights and interests to go to blank line, and you filled it in, and that person's willing to accept that 60% interest, then that avoids probate. Otherwise, the entity, your interest in the entity will go through probate. How much do lawyers generally charge to settle a trust estate? Well, Marilyn, if the trust is properly set up and funded, you shouldn't need you shouldn't need attorneys. The trustee has power to do everything. The assets are there. You might use the attorney to make sure that everything is distributed properly, but the trustee has full power without using an attorney. Is that wise? Whether it's wise or not, it's often done where the trustees just distribute the assets according to the trust. How do you fund into a trust real estate owned by one domestic partner to the other? It depends on your state. If it's in the trust and the other partner is a co-trustee, I need to know a little bit about your state and the state laws. So I don't know how to answer that one. Benny, the only one trust was a question about wording on marital persons trusts. When you do a marital trust, you're creating one document, but really what it's doing is when the first person dies, it can create a separate trust in itself. That one becomes irrevocable. We call that the B trust. I remember that because the person's below ground. The other person, the remaining trust, the successor or the successor's trust, is the A trust. I remember that because the person is above ground. The B trust becomes irrevocable. This is irrevocably going to go to the children. And even though I really created one document, it really can create three trusts within the trust. And if you don't want to get more complicated, on a Q-tip trust, I've got one for the husband, one trust for one document, one trust. But upon death, it creates an A trust, a B trust, and for assets that were arrived at during the marriage, there could be a C trust. These are jointly owned assets, and so even though it's one document, you can create multiple trusts within. There could be a provision where upon death, some of the money goes into a separate children's trust, and so it doesn't really matter how many trusts are created. It's really one document, I think is what you're asking. A lot of people need protection from predator guardianships and trolls that would be guardians, but irrevocable does not work in many states. Oh, revocable trusts work in all states. The fact that it's a private document and most people don't know that you own it makes it very, very, it's a private document. Bob Hope was said to be one of the richest men in real estate in the state of California ever. He owned billions of dollars, assumedly, in real estate holdings, but we don't know what it was. It's not a matter of public record, and he chose not to disclose it. It was in his trust. Did he have separate LLCs for each property? I don't know, but what his holdings all were in a very private revocable trust, and unless your family members or his attorney, it was never disclosed what he owned. If I have a durable power of attorney over my parents and my dad, and my dad becomes incapacitated, he has a will. Can I take the trust as durable power of attorney? You have the durable power of attorney. He has a will. So if your power of attorney is kicked in, could you create a trust for your dad? And the answer is yes. If the power of attorney, you'll have to read it. If it says you have the power, it lists all the you can set up bank accounts, you can do taxes, and it'll list multiple things that you can do. If it says that you can create a trust in your parents' behalf, then yes, you can. But I'd have to go back. You'd have to go back, Faith, and look at the powers that he allotted you, and if he gave you powers to set up a trust in his behalf, then absolutely you could. I'm not able to attend all 3 days. Will there be recording for the 3-day summit? And the answer is we have to record it for compliance purposes, but we don't make that available. We will cut up sections and list those on YouTube, but if you can't possibly attend all 3 days, do the very best you can and attend as much as you can. And then you can come back again another time and the content doesn't change a lot. Scott Essel will always change his presentation. It'll always be current. Clint, I have no idea what he's going to say once we put the mic in front of him. And so every time he teaches new things. But I'm pretty consistent, and you all do different things. But for the most part, we're covering the same content because our students tend to need the repetition. Kenneth, you're incredible. Thank you very much. Thank you, Kenneth. I appreciate it. Maria, if you insure your property home under the umbrella, are you protected from liabilities? Yes, for the most part you are, but read the policy and read it really well. And because every insurance policy will say, here's what we'll cover, but here's what we don't. And read those. My policy is like 34 pages long. The first 3 or 4 pages define the terms, and then there's 2 or 3 pages that say here's what we'll cover, and then the rest is saying here's what we won't cover. Know that the best insurance, the highest paid attorneys in the nation work for the insurance companies, And insurance companies make a lot of money collecting premiums and denying claims. So read your policy. And don't just, well, I've got an umbrella policy for $1 million and think you're secure, because sometimes, often you're not. Okay, Maria, are you protecting liabilities if you put your home in a trust? No. Carry good insurance, suck out the equity. There's things we're going to teach you, rely on homestead. When you get to the summit, we're going to teach you how to protect the home. The Revocable Living Trust is a probate tool. That is all. It doesn't do anything else other than it avoids probate. Sometimes we've got to combine that with other things to protect it. We didn't talk really asset protection tonight. We really talked probate. Hope that was helpful. Okay, Kendall, any other kind of remaining thoughts, or did we miss anybody?
No, you did good, Don. I learned a lot too. It's amazing. Thank you so much. No, great questions, class, too. Really good questions.
Aren't you really glad we didn't go through that other half hour on land trusts? And I'm sorry we didn't get to that. And I should have drank more water. I'm a little dry after this, but thank you all for being here. We do answer a lot of questions. The hotline is open. And I hope that you get a chance to attend the summit. If you've attended, come back and see us, especially watch Kevin O'Leary. This will be kind of a first time for us to have Rockstar Kevin on our stage. We're excited about that, but incredible insights into what's happening with the market, with inflation, with government policies, how that's affecting his investments nationwide, worldwide. I hope you join us. So thank you for being here. Thank you for your questions. And most of all, when you could have been anywhere, you were with us. We appreciate that. And we respect that and feel very privileged that you were here. Thank you very much. Make it a great night. Bye-bye.